Afternoon, everyone. We might just give it a few more seconds for a few more people to log on and then we'll get started. For those that are already in the room, you may already know, but you can access some resources from the webinar today that are accessed on the right-hand side of your screen under the resources tab. So you'll be able to access those before and after the webinar. Okay, so we might get started. So my name is Stacey Ullman. I'm the Manager of Sector Engagement and Development at the National Centre, and I'll be hosting your session today. We're really happy and fortunate to be partnering with Knowmore to bring you today's session on navigating Australia's child safe legislation. And we are joined by Rachel Neal, the Executive Director of Integrated Services, and Amy Barrett, Principal Lawyer Projects from Knowmore. And we'll introduce the session a bit more once we've gone through our acknowledgements. So before we start today, we'd really like to respectfully acknowledge and celebrate Aboriginal and Torres Strait Islander nations and pay our respects to ancestors and elders past and present across Australia and wherever you're joining us from today. I'm coming to you from Gubbi Gubbi lands on the Sunshine Coast in Queensland and really recognise that Aboriginal and Torres Strait Islander communities, culture and law continue to lead Aboriginal and Torres Strait Islander communities, and really want to acknowledge the tireless work to pursue justice outcomes for children and young people that's undertaken by each and every one of those communities. We seek to honour the lived and living experience and expertise of all victims and survivors of child sexual abuse across all ages, cultures, abilities and backgrounds, and really commit ourselves to substantially addressing the harm of child sexual abuse, not only now, but into the future. And as a final note, we also recognise that there are children and young people today who are experiencing child sexual abuse across Australia, and really dedicate ourselves to doing all we can to expedite and promote their effective protection and care. So as part of the session today, we really want to make sure that you're aware of different supports that you can access either throughout the session or afterwards. There's information that you'll hear today that will contain sensitive content. We also know that child sexual abuse has a ripple effect, and many people here today and across the profession and different workspaces that you work in are also victim survivors themselves. So we know the rates of lived experience is high. Please look after yourself, step out if need be, and if you do need to reach out to supports, we absolutely would encourage you to do so. As another note, this information that we have within the session today must not be relied upon as legal advice, and you must seek further legal advice around particular circumstances. As a bit of background to the National Centre, so the National Centre for Action on Child Sexual Abuse was a key recommendation of the Royal Commission and was founded in late 2021. It's a partnership between the Australian Childhood Foundation, Blue Knot Foundation and the Healing Foundation. And we have a singular focus on child sexual abuse, looking across the lifespan. We have three key strategic goals. The first one is to empower victims and survivors. The second, to build sector capability and responsiveness. And the third is to drive policy, systems and cultural reform. And the ongoing work of the National Centre focuses on experiences of child sexual abuse, both for young people and children, but also looking at historical experiences for adults as victim survivors of child sexual abuse. So we're really pleased to introduce Knowmore as our partners in the session today. So if you are not familiar with Knowmore, they are a free national multidisciplinary community legal service who assist victims and survivors of child sexual abuse. They have extensive knowledge and expertise in navigating Australia's child safe legislation, and many of you will know of and be connected with Knowmore previously. Knowmore offers a multidisciplinary approach that includes legal advice, financial counselling, law reform and advocacy, and also support services and Aboriginal and Torres Strait Islander engagement. They started work in 2013, supporting people to provide information to the Royal Commission into institutional responses to child sexual abuse. And since then, Knowmore has supported many victims and survivors of child sexual abuse through free legal advice and support. So representing Knowmore today, we have Rachel Neal, Executive Director of Integrated Services. Rachel has worked at Knowmore since 2019, and immediately prior to working at Knowmore, Rachel was Principal Solicitor of Women's Legal Services Queensland and held several roles over an 18-year period, working in domestic violence and family law. She spent her legal career committed to helping vulnerable people access their rights within a strong framework of trauma-informed practice. And we also have Amy Barrett, and Amy's Principal Lawyer Projects. Amy's worked in the Sydney office of Knowmore Legal Service since 2021. She previously worked as a lawyer in Legal Aid New South Wales, assisting New South Wales Aboriginal communities with a range of civil law matters, including applications to the New South Wales Stolen Generation Reparations Scheme. She's also worked with clients in custody, young people in out-of-home care, and clients associated, clients involved in sexual assault proceedings. Amy has also worked as a senior native title lawyer representing New South Wales traditional owner groups and has been the New South Wales State Manager of Native Title Tribunal. So the session today is really designed to equip you with the critical knowledge needed to navigate the legal and legislative landscape when working with and supporting victims and survivors of child sexual abuse. So we'll explore 3 different elements today. So mandatory reporting, looking at the legal obligations and procedures for reporting child sexual abuse. Age of consent, so how consent laws impact case handling and support. And the age of criminal the age of criminal responsibility and the implications of criminal responsibility in cases of sexual abuse. And there are factors of age that may impact and affect mandatory reporting. So you will see that there's a Q&A function in place to encourage discussion and feedback. We do note that specific questions may not be answered within the session. However, if we can't answer any questions, we will take them on notice for future sessions and resource development. There will be a disclaimer popped in the chat as well for you, but really want to be clear that the focus of the session today is to provide an overview of legal and legislative environments and obligations. It is not provided as or cannot be relied upon as legal advice. You're encouraged to seek separate legal advice and expertise around your own particular circumstances, whether that's for yourself or people that you're working with. And if you've just joined us, there are handouts in the chat that are hopefully some use for you today and into the future. One of those is a spreadsheet detailing different laws in different parts of Australia under different jurisdictions, and really want to acknowledge that that is up to date as of today and may change as future changes occur within jurisdictional situations. So that is it for the introduction and summary of the session today. Do want to provide a little bit of broader context before I hand over though around why we're partnering with Knowmore for this session. So we know through the feedback from 2 learning and development surveys conducted by the National Centre that practitioners and workers really want and need further information around legislation, the application to practice, and how can they strengthen responses. So today's session is focused on legal frameworks, their application, and we really want to recognise that the environment that we all operate in and how we apply child safety frameworks in various practice settings to respond to and support children and adults is not always clear, can be really different depending on where you're working. And of course, there's different circumstances, situations, and variables to consider and understand. We know that mandatory reporting is an absolutely critical part of safeguarding and protecting children and young people, and understanding our individual legal obligations is really important. We also know that when we talk about mandatory reporting, that's not where our obligations to support and protect children and young people end, or for adults with historical experiences of child sexual abuse end. The landscape around mandatory reporting does differ across different states and jurisdictions, and you'll hear that today. It does include reference to both child protection and criminal law frameworks, which we will explore further today. But again, noting different considerations and requirements do apply in respect to different professions and qualifications that people may hold. We also just want to acknowledge the history and current context of mandatory reporting and child protection systems for First Nations people and communities. We know very clearly from First Nations communities that there are significant issues as to how reporting occurs and what happens after reporting, particularly in terms of the current and intergenerational impacts on children, young people, families, and communities. So we'd really like to hand over to Amy and Rachel now, and we'll get started with the session.
Thanks, Stacey, and thank you for that introduction. This first slide before we jump into the training is a quote that builds off what you've just said, Stacey, about acknowledging that Aboriginal and Torres Strait Islander children are disproportionately represented in the child protection system, and that this reflects a lot of historical practices, the impact of colonisation, systemic racism, and government policies like the stolen generations. And Auntie Glendra Stubbs is the elder in residence at Knowmore Legal Service. And when we first spoke to her about us presenting in this context, she really wanted to share this quote that you can see on the screen today. And she really wanted people to acknowledge those disproportionate impacts of involvement of child protection in the lives of Aboriginal families and communities, and that the level of distrust that some Aboriginal people and communities have in relation to child protection authorities for the reasons we've just mentioned. So yeah, I'll leave you to read that. And we certainly recognise the strength and resilience of Aboriginal families and communities, and Knowmore certainly commits to engaging with mandatory reporting laws in a culturally safe way that supports family, culture and self-determination. All right, well, today's training session is in relation to mandatory reporting, and Rachel and myself, we're both lawyers at Knowmore Legal Service, and so the context here is that we work in a multidisciplinary organisation. As Stacey said, we have a lot of people from different professional disciplines who work with and alongside us in the legal service, and so we have had to turn our minds to the different roles that our professional staff have and the different legal obligations that we have as a result of that. And that's the background to us sharing some of those learnings with you here today. So this particular session is focused on mandatory reporting and on what our legal obligations are when we get disclosures of and information about child sexual abuse. And we want to kick off with a brief discussion in relation to confidentiality, as mandatory reporting interacts with the various professional duties that we might have within our different roles in relation to confidentiality. And this is certainly something a starting point that we turn our minds to. So in our various professional roles, we often have a range or a number of duties in relation to confidentiality. And these can stem from various sources, usually contracts of employment. Our contracts of employment usually have a requirement about confidentiality of the information that we obtain in the course of our employment. And professional bodies usually specify what confidentiality requirements apply. So if you're qualified or registered as a professional, you will have to follow the various codes of ethics or practice standards that relate to your profession, and these will specify what confidentiality duties are required. So, for example, lawyers in Australia are bound by the Australian Solicitors Conduct Rules. And for example, social workers need to comply with the Australian Association of Social Workers Code of Ethics and practice standards, and similarly across other professions. So one of the resources that's available today and that Stacey referred to is a table that we've produced on confidentiality requirements. So this is a handout that goes through what some of the profession-specific requirements are around confidentiality. It certainly summarises some of the different disciplines that work at Knowmore Legal Service. So this is a good starting point for being familiar about what specific requirements apply to you or others in your workplace if you also work in a multidisciplinary environment, and it also sets out what exceptions might apply as well. And very generally, there are exceptions to duties of confidentiality in cases where there is a serious risk of imminent harm to someone or to another person that you become aware of. And another common exception is where the law explicitly requires you to breach confidentiality. So across a range of professions, you'll find that there are common exceptions. So this means that where the law does require you to make a mandatory report, which we'll be running through shortly, this will override any professional obligations that you might otherwise have in relation to confidentiality. In relation to lawyers, mandatory reporting does raise some particularly complex issues because lawyers have an additional level of legal professional privilege, and that adds an extra level of confidentiality or protection from disclosure for certain communications between lawyers and their clients in the course of giving legal advice or preparing for legal proceedings. And in most cases, this particular privilege does override mandatory reporting requirements, or as an exception to mandatory reporting requirements. And we're going to be touching later on some other exceptions that apply to mandatory reporting laws. We acknowledge that if you do breach confidentiality to make a mandatory report, it can often be damaging to your professional relationship with a client, which has significant flow-on effects for your ability to continue to work with them and support them, which is extremely important in this kind of work. So wherever possible, we here at Knowmore, we certainly talk to our clients to let them know that there are limits to the legal confidentiality that we can maintain, and that in some circumstances reports might be required, and we certainly do let them know if we have decided that we are required to make a report, and wherever possible we do also talk to them about making their own report so we can overcome the need to breach confidentiality. There are some other laws about that relate to confidentiality and when that confidentiality can be breached in a legal context, such as records being subpoenaed in court proceedings. But we're not going to be talking about those in detail today, as we're only discussing the laws that relate to mandatory reporting. So the purpose of mandatory reporting laws is to protect children and young people from harm by legally requiring certain individuals to report any known or suspected cases of certain types of child abuse or neglect to government authorities. Each state and territory has different laws about who is or is not a mandatory reporter, and when they have to report and who they have to report to. And most states and territories have more than one law about mandatory reporting as well. So most jurisdictions have two different legal frameworks, one that relates to child protection and one that relates to criminal law. So that the first, the child protection framework, is where the laws are usually set out in a Child Protection Act, and it will identify people in certain professions who are mandatory reporters, and these people are required to report any concerns about child abuse that they come across in the course of their professional work. And the other framework is the criminal framework, and this law is usually set out in a Crimes Act and applies to a much wider range of people. These laws are sometimes called the failure to report laws, as they set out penalties for not reporting when individuals are aware of or believe that a child abuse or child sexual offence has occurred. So we will go into this in a bit more detail, but another resource that we've prepared and that's available today is a spreadsheet that covers the relevant laws in all the states and territories in relation to both of those frameworks, and it can be used to refer specifically to your jurisdiction or to any jurisdiction that you work in, and it will summarise the requirements in relation to each location. And that resource is current as of today's date, and we encourage you to use it, and we'll go into it in a bit more detail. One thing we'll also say up front too is that even though this session is about what the legal requirements are to make a report, in your various professional practices, you can also consider taking action to report abuse, even when you're not mandated to do so by making a voluntary report. I'll hand over to Rachel.
Thank you, Amy. Okay, so there's a lot of laws here. When you look at that spreadsheet, you'll see that it's quite complex. And so because of that, we really are not able today to go through it state by state. But despite the different legislation in different places and jurisdictions, there are some really common features with mandatory reporting. And they generally cover 4 things: who, what, when, and where you report. And that's how we're going to structure this discussion today. We hope that we can provide you with a decision-making framework and a broad understanding of the way to work through a mandatory reporting issue. And then you'll be able to go to the spreadsheet and have a look at what your specific jurisdiction requires from you. We'll also be talking about when you've got cross-jurisdictional issues, which is a thing that comes up. So, yeah, we'll be looking at what needs to be reported, and there's a bit of content that Amy's going to go through that. We'll be looking at exactly what has been disclosed and what is your understanding of the risk that this poses. And then there's a few other things we'll be looking at, which is the age considerations of the person who made the disclosure and of the person who is at risk, and also the age of the person who is abusing. That will come into the age of criminal responsibility and consent, and we'll be looking at some exceptions, as Amy said before. The detail of this is in the spreadsheet in columns, and I hope that that's useful for you. So firstly, I want to look at who is required to report. Again, it depends on your jurisdiction, but in those 2 broad frameworks that Amy was speaking about, I'll first talk about the child protection framework. So people who are likely to come under this, who are likely to need to mandatory report under this framework, are people who are likely to come into contact with children in their professions. So health, education, juvenile justice, religious institutions, range of social work and counselling, youth work, welfare. There's a lot of those professions. What's really important here is that the information that you receive has to be obtained in the course of your work for this to be triggered. Have a look at the spreadsheet as to who comes under the laws in your specific jurisdiction, but you will see that commonly that teachers are mandatory reporters in all jurisdictions. Social workers also are. There's a few outliers there. In Tasmania, MPs are also mandatory reporters. Generally, lawyers do not come under that child protection mandatory reporting framework. So that's your child protection framework. On the other hand, we have the criminal framework. And in most circumstances, this will apply to all adults. So it's going to cover a lot more people, but generally the threshold for having to report will be higher because this is focused on a crime having been or likely to be committed rather than the focus on risk, which is the focus of the child protection framework. So the reason that we talk about the criminal framework is that even if you're not a reporter in your professional role under the child protection legislation, you may be a reporter in your capacity as just a member of the public under the criminal framework. So there's a couple of ways that this might come up in our workplaces. We may be workers and we're getting information from clients or patients directly. We also need to be aware that our clients themselves may be mandatory reporters under the criminal framework as a member of the public. So we may be needing to tell them that they might be required to report. It's also important to consider disclosures that might happen at work that are not related to our client work. For example, disclosures by co-workers. They may make disclosures to you that triggers mandatory reporting. And then we also need to think about what might happen outside of our work in social settings. And I would note that in some cases, the nature of the work that we do may mean that we're more likely to receive disclosures in our personal lives. If you're talking to people in a social setting about what work you do, that can often lead to that. So keep that in mind, that this is not just in the role that you're doing. There's also another number of places where this might give rise to a mandatory reporting requirement. And as Amy said before, voluntary reports can be made by any adult, even if you're not required to do so. Back over to Amy, thank you.
Okay, so now we're going to look at what is required to be reported, and this varies across each state and territory, but broadly speaking, there are 5 categories of harm to children and young people that need to be reported in different jurisdictions. The first is child sexual abuse, which we're here to focus on today. And although there's no common across all those jurisdictions definition of child sexual abuse, it is generally considered to be any sexual activity or behaviour that is imposed on a child or a young person by another person. It can include sexual activity, exploitation, assault. It includes grooming and conduct of a sexual nature. It can include touching and also non-contact behaviours such as exposure to sexual content. So those forms of abuse are required to be reported if you are a mandatory reporter in all jurisdictions, as we've summarised on the slide there. Some and many of the other categories that we're about to run through are certainly often encompassed by reports in relation to sexual abuse as well. So another area is physical abuse. So this is any intentional or reckless harm that causes physical injury or pain to a child or young person. So all of the jurisdictions except Western Australia are listed there: ACT, New South Wales, Northern Territory, Queensland, SA, Tasmania and Victoria. There's also the category of emotional and psychological abuse, which is abuse that might have a long-term effect on the development and well-being of a child, and the jurisdictions are listed there where that is required to be reported: New South Wales, Northern Territory, Tasmania and South Australia. Neglect is a category that generally refers to the failure to provide essential care and support to a child or young person, and that's required to be reported in New South Wales, South Australia, Tasmania, but also Northern Territory as well, which is not listed on the slide, and we'll update that. The final category is exposure to domestic and family violence, which encompasses exposure to family violence or harm from a family member or in a domestic setting. And the areas where that would need to be reported are New South Wales, Northern Territory, Tasmania, and also South Australia. Again, we'll update that slide for next time as well. And as I said, it is accepted that sexual abuse will likely encompass other forms of harm as well, such as physical and psychological harm. Rachel will now run through what level of reasonable suspicion and belief is required for reporting.
Yeah, okay. So this is nuanced and a bit complex, so it's really going to depend on a case-by-case basis. But all of the laws talk about either your reasonable suspicion or your reasonable belief that abuse has occurred or is likely to occur. So this is looking at how you assess the risk posed by what has been disclosed and the certainty or otherwise of that risk, depending on the information that you've got at hand. So what is the difference between the two, reasonable suspicion and belief? Suspicion is generally a lower threshold than belief. So a reasonable suspicion is a rational concern based on observed facts if we're looking at a strict definition, and a reasonable belief is a justifiable conviction based on some evidence. I would say that if there is a suspicion, then you really are looking at delving into it more deeply to see if that there is information that would give rise to an obligation. So the evidence that you'd be looking at, or the information that you've got, it might be signs that you've observed of a child, of their behaviours. It might be information that indicates that a child or a vulnerable person might be at risk of harm. And it's about taking that information and objectively assessing it. So objective means looking at the facts and the evidence and verifiable information. Subjective, on the other hand, means information or perspectives based on feelings, opinions, or emotions. So you need to be taking a step back and looking at it from an objective rather than a subjective position. However, when I talk about facts and evidence, that's we need to understand that we don't need to have strong evidence to make a report. What you're really looking at is whether a reasonable person with your particular skills and experience in the same position as you would have formed a belief that there's a risk. You don't need proof, and it's not your job to gather evidence. It's not your job to get the proof. But it is important to remember that it's about with your skills and experience when you're making this assessment. So, for instance, a child psychologist who's trained in child behaviour, appropriate child sexual behaviour, will have different skills and knowledge to a lawyer, for instance. And so it's important to remember that you're not expected to be this all-knowing oracle about child development when you're going through this process. So some examples of some information that you might be assessing that would probably reach that reasonable belief threshold is if a child tells you that they've been sexually abused. That's a fairly obvious one. The child might tell you that they know someone who's been sexually abused, and this may be a way of talking about themselves, and it will depend how well you know the child as to how you assess that. Someone who knows the child might tell you that the child's been sexually abused, or you might be a qualified professional who's observed the child's behaviour or development that makes you believe that they've been sexually abused. So the most common one will be sexualised behaviour from a child who is too young to have that developmental knowledge of the behaviours that they're exhibiting. So that's a matter of really looking at the age of the child and the appropriateness of that. I'm not going to go through ages of that, but there is a New South Wales government mandatory reporting decision tree, and a lot of mandatory reporting, I guess, online aids might help with this. So it gives some age-appropriate sexual behaviour in bands of age of children. So that could be helpful. But again, you're not expected to be an expert in this if you haven't got the skills and qualifications. What's important is that you don't need to report rumours or unfounded suspicions. And we're going to go into a bit of an example of that a little bit later when we go through a scenario, which is coming up now, in fact. So, Amy, I might get you to kick off with the scenario.
Yeah, so this scenario is written on the slide there. You're a teacher at a state school who has developed some concerns about a young student. At the start of the term, you become aware that her mother has a new partner, and after a few weeks, you hear from another parent that there were rumours that the new partner had abused a child of a former partner. After a few months, you notice that the child is starting to play sexualised games with the other kids. And so the question is, do you need to report this, and what else would you do? So we'll just sort of run through this. Obviously, the first question is we're turning our minds to are you a mandatory reporter? And, yes, teachers are mandatory reporters in all jurisdictions under the relevant child protection legislation. So this is a question of, what is required to report, to be reported, given that we do have that duty to report any reasonable suspicion of sexual abuse. So, Rachel, what do you think would need to be reported here?
Well, I think we've got two elements of concern or suspicion. We've got the child's behaviour, and we've got the suspicion or the rumour, I guess, that the child might possibly be living with a child sex offender. We're not even sure if the offending was against a child. No, we do know that. So those two suspicions. So firstly, in relation to the behaviour, we don't know if abuse has occurred, obviously, but I would think that this, we will make an assumption for the purposes of this that these sexualised games are not within developmental, the normal developmental stages. And yeah, I think we've got reasonable grounds here to suspect that something's going on. Yeah, the teacher themselves are going to hopefully have enough experience to know what is out of the ordinary and what isn't with sexualized behaviour. So I think that we do have reasonable grounds here. With respect to an exposure to an existing offender, it is just a rumour, and it's sort of a second, potentially third-hand rumour. If it's true, though, then this is a serious risk factor combined with the fact of what behaviour you're looking at with this child, and it would sort of back up those suspicions. I would say that if we were making a report to child safety about the behaviour in any case, then that information should also be given to them. They should have information, or they should have access to a database or information about convicted or child sex offence, the child sex offenders register. So there should be information sharing that's available with that.
So do you think that we should try to find out more about this situation before reporting? I mean, I know you said before that it's not your job as a mandatory reporter to gather evidence. But yeah, do you think we require more information, and how would we get that?
Yeah, I think this is a really tricky space to be treading in. So you could have a conversation with the child, but you'd want to be really careful that you're not sort of fishing for anything here, because it could contaminate evidence if this came up later on. You could refer the child to a school counsellor and have the counsellor speak to the person, to the child. They may have extra training in that, but again, you'd want to be really careful. The child may make further disclosures about mum's boyfriend, but we just don't know, and we want to be careful here. But I think it's also important to know that disclosures by children isn't a singular event, and there may be a conversation that needs to happen, maybe with the school counsellor, to give the child a chance to let you know what exactly is going on.
And so beyond the legal obligation to report, noting that that's not the only reason you might choose to make a report, are there any other steps that we should take to protect the child here?
Well, I think that you've, I think probably we are going to be reporting, so we've got that. But we have to remember that teachers and others in similar roles have a duty of care to the children in their care, and taking other action that might be available to support the child and the family could also be really important here. The immediate priority, of course, is making sure that the child is safe if any imminent risk arises from a disclosure or from behaviour. You could meet with the mother and offer support, such as referrals to support services, set the child up with a counsellor, that sort of thing. But again, you want to tread fairly carefully here, because we don't want to put the child in a position where you've told the non-abusing carer, if you like, that there are suspicions, where we just don't know enough about the family dynamics here and how the child is going, how that's going to play out for the child at home if you have those conversations. So it would really depend on the teacher's relationship with the family and what they know about the family. With a school setting, you'd probably look to the education department protocols and policies with this as well, and have a look at whether, what other supports might be available.
Well, what about the situation if you, same situation, but you're not actually a teacher, but you're actually a parent at the school, and you observe the same behaviour or obtain similar sort of information or disclosures from the child when they're at your house, for example? So not as a teacher. Would that change how we approach this situation?
Well, as a person in the community, we've got the criminal framework to consider, and we'd be looking at whether we think that there's whether what you're observing or whether any disclosures have made gives rise to either you believing that a crime might have been committed or is likely to be committed. So that could be a tricky one for someone who's not trained and doesn't have knowledge of those sorts of things, but it may arise for you, and I think it would really depend on what is actually being observed and what has been told to you. But if in that setting a child came to a parent and said that they have been abused, then that would definitely give rise to mandatory reporting obligation under that criminal framework.
Okay, thank you for that. So it does seem that we would, certainly in our capacity as a teacher, we would be reporting reasonable suspicions in this scenario, and also quite possibly in our capacity as just an adult member of the public as well. So yeah, and as we've said, it's worth remembering that just because you're not required to report in a particular jurisdiction, for example, it doesn't mean that you wouldn't take steps to make a voluntary report.
Yeah. And if you're in doubt, seek advice. We're going to give you some resources and places that you might be able to go, and your professional bodies may well have support for you as well in your professional roles. So seek advice. You're not on your own in this, and that's important to remember. Over to you, Amy.
Yeah, we're going to move on now to talking briefly about some issues around age. And so firstly, we're going to talk about the age of consent. Age considerations do or are likely to interact with aspects of mandatory reporting laws. So firstly, we want to be really clear that the law the law is very clear that children do not have the ability to consent to sexual activity. So any involvement of children or young people in sexual activity is a crime in all jurisdictions. We want to talk, however, about the age of consent as that is a consideration here as well. Each jurisdiction sets an age at which young people can legally consent to sexual activity. And this law is known as the age of consent. And again, we've produced a handout that you should have that summarises the age of consent and consent laws, the legal age of consent laws in each jurisdiction. And so please have a look at that. You'll see that the age of consent is 16 or 17 in all jurisdictions, and that most jurisdictions also have what's known as a close age defence. And this is a defence to a charge of a child sexual offence if there is an age difference between the two young people within a certain number of years, and the younger person was above a prescribed age. So, for example, in New South Wales, if the young person is 14 to 16 years old and the age difference between the two young people is no more than 2 years, then that would fall into the close age defence. And where this applies, or where the age of consent applies, it may mean that any consenting sexual activity is not deemed to be a sexual offence and would not require reporting under the criminal code framework that we've been discussing, that would otherwise require the reporting of a belief that a child sexual offence has occurred. Also wanted to mention that regardless of the age of consent, it is a criminal offence for anyone in a role of authority, supervision, or care of a young person, what are known as relationships of care, to have any sexual contact with a person under 18. And although these laws vary across the jurisdictions, and again, we have put them in the handout, they generally apply to people in positions such as parents, carers, school teachers, health workers, workers in home care, out of home care settings, and people who might have a personal relationship with a young person through the provision of religious, sporting, musical, or other instruction. So those relationships of special care are very clear that any sexual contact with young people under 18 is illegal. We wanted to move on to talking about what is consent. And so even if people, or young people, are of a consensual age, we just want to emphasise that consent is still something which needs to be freely given by both parties to any sexual activity. The definitions of consent vary across the different jurisdictions, but in all jurisdictions, the general legal concept is that consent is something which must be freely and voluntarily given, and cannot be given where there's any coercion, coercive control, threats, or intimidation, or where there's any impaired decision-making capacity. So that includes by drugs or alcohol. And also that consent can be withdrawn at any time. You'd also be aware that affirmative consent models have been adopted in a number of jurisdictions around Australia. So they've been adopted in Tasmania, Queensland, New South Wales, the ACT and Victoria, and are being considered in other jurisdictions. So this means that the parties to any sexual activity need to actively do or say something to show consent rather than consent being assumed. And we're now going to talk about the age as it relates to the age of criminal responsibility.
Thanks, Amy. The reason that we're talking about this is that it may, where we have a child who's using harmful sexual behaviours against another child, the age of the children exhibiting those behaviours may be relevant to which framework you might be required to report. So that's why we're going through this. The next slide talks about the fact that a child under 10 can't commit a crime under our law. So if the child exhibiting harmful sexualized behaviours is under 10 and the behaviour comes under what you would usually give rise to, you know, the threshold as to what needs to be reported, you would report that to Child Protection because it's not a crime. The child is under 10. there is harm, potentially harm to another child, but it doesn't come under that criminal framework. I'll talk later about which framework you would be reporting on under. But if the child has, if the child is aged between 10 and 14, whether that is a crime really depends on whether the child has the capacity to understand what they're doing wrong, what they're doing is seriously wrong. So the legal term for this is dole incapax, and it's an assumption that a child between 10 and 14 is criminally incapable unless proven otherwise. So the law is going to look at the particular child, what they understood about what they did they know that it was wrong, and then decide whether they are criminally responsible for what happened. It really depends on the child and their level of understanding, and you may need to, if they know that what they did was wrong, a report to police might need to be made. I think that it's important that we know that in this whole mandatory reporting process, it may lead to a child who's exhibiting harmful behaviours being charged with a criminal offence. It doesn't happen very often, but it is a possibility. In terms of children over the age of 14, there's controversy around that, and you may have seen campaigns around raising the age of criminal responsibility. I think it's also important to remember that if a child under 14 is displaying harmful sexual behaviours, there's a really good chance that this stems from their own trauma and potentially their own sexual abuse. So a therapeutic approach of support for that child and their family is going to be far better than criminalising them and locking them up. We know that incarceration of children can contribute to them offending further, but can also expose them to physical and sexual abuse if they're in detention. Now, we're not saying that the police are going to come in and arrest and charge children who are of this age, and we would hope that they would take a more therapeutic approach to it. But from your perspective, from a worker's perspective, when you're looking at a child using those harmful sexual behaviours, look at the age of them, what they understand, and whether it falls within that criminal framework or whether it falls within the child protection framework. And like I said, a report to police isn't necessarily going to mean that the child's going to be charged. The police are going to be will have their own child protection units that will be linked to child protection authorities, and so we would hope that that referral to child protection authorities would lead to support of that child that's using the harmful behaviours. Okay, the next slide we're going to look at is another scenario, and I'm going to just go through it. So you're a social worker working with a woman who's experienced family violence. She tells you that her 15-year-old daughter is in a sexual relationship with a 17-year-old boy from school. We need to look at how do we assess the situation and how do you report. What do you think, Amy?
So firstly, I'd be looking at, as a social worker, are you a mandatory reporter? And so, yes, social workers are mandatory reporters in most jurisdictions under one or other of the mandatory reporting frameworks, or under what's specified in that sort of ethical professional duties for social workers. So I'd be saying yes, social work is a mandatory reporter. I'd be noting that the young person here is 15 years old, which is below the age of consent, which is 16 or 17 in all jurisdictions. However, I am noting that the difference in age with the boy from school is less than 2 years. So that might raise that close age defence that we were talking about before. And this wouldn't negate any responsibility, but it's just highlighting that it's not just about age, but about the nature of the relationship there. So that might raise the questions of, is this a consensual relationship? Does the mother have any concerns about the consent being freely provided by the daughter, or are there any issues of power and control, or cognitive capacities, or impairment by drugs and alcohol that might indicate a lack of consent that would need to be taken into consideration in this case? Or are there any other sort of risks for the well-being or safety of the young person, as this would be relevant to assessing whether the young person is at a risk of serious harm? So that would be some of my considerations.
Okay, so probably without if we don't have any more information around the consensual nature, and we assume that it is, we probably wouldn't need to report this. It's not an offence due to that closed age defence, and it's a consensual relationship. So the age of this young woman, young girl, is not in of itself a reason to report. I'm just going to throw another scenario to you, Amy. So you're still working with this woman, and she tells you that her daughter's become withdrawn and uncommunicative. She's seen bruises on her daughter's arm. So do you think that this might change your response to the situation?
Yes, I think that could affect things. So we would need more information about how did she get those bruises. I mean, if it was from the boyfriend, this could definitely be a factor in reconsidering the issue of consent, or it might indicate that there's other physical assault offences being committed that might then reach the threshold for reporting a risk of harm to a child or young person. So yeah, I think that could change the scenario depending on what information we get. One thing I might just mention is that the social worker that we're working, well, that's us, isn't it? Working with this woman, the woman has come to us because she's experiencing family violence, and so I think we need to assess any possible danger to her or to someone in that circumstance. If you do decide that a report needs to be made, as there is the possibility that could expose her to some risk in her personal family violence situation. So we'll address that shortly when we talk about exceptions and what are considered reasonable excuses or exceptions to mandatory reporting. Okay, we're going to move on now to talking about reasonable excuse, because as we mentioned earlier, there are some circumstances where the abuse might not need to be reported. So both of the frameworks, the criminal framework and the child welfare framework, both allow for reasonable excuses for reports not to be made, or under the criminal framework, defences. So we have listed these on the original spreadsheet that we were referring to. So please use that as a resource for what some of those exceptions are. So even though they do vary from place to place, there are some general common exceptions. One is if you believe that the information that you've obtained, or the disclosure you've obtained, is already known to the police or child protection authorities. And this might be because it's already been reported to those authorities, and the client or the person that you're working with might tell you that they've already done that, or you might know that the perpetrator has already been convicted of the offence against that child. although in relation to that we do need to be careful, because we know that child sexual abuse isn't a single offence. It's often not a single offence. It can be a series of behaviours that do escalate in severity or continue over a period of time. So we do have to be careful not to rely on that exception if there are new disclosures or new information that comes to light, even if you're satisfied that the original information is already known to authorities. And the Victorian child protection legislation actually specifically states this, and it says that each time there is new information, it must be reported. But the same principle certainly applies across other jurisdictions. So another exception is if you believe that reporting is going to place the person or another person in danger. So that would include a family violence situation, which I mentioned before. And for example, you might have knowledge that the perpetrator is violent and has actually taken retribution against people who have reported them in the past. So that risk needs to be actively balanced with the safety of the child in a situation like that. So in a situation like that, you might want to consider the fact that reporting can be done anonymously. And we're going to touch on legal protections of reporters shortly. Another exception is if the victim is an adult at the time of the disclosure and they say that they don't want it to be reported. And we come across this situation quite a lot at Knowmore, where we talk to a lot of people who have experienced historical child sexual abuse. In Victoria, this exception is also listed as applying to people over the age of 16, where the victim survivor has directly requested that it not be reported. And lastly, as we sort of briefly mentioned, in relation to the concept of privilege, so legal privilege, that is relevant as well. Another important defence to the reporting of an offence under the criminal framework is where the information is privileged. And as discussed earlier, this applies where information is legally privileged, although there are other kinds of privilege. And in nearly all jurisdictions, this legal privilege overrides any mandatory reporting requirements, possibly not in the Northern Territory. So they are some of the exceptions. We now want to discuss when, in terms of the timing of making a report. So the core purpose of the mandatory reporting regime is obviously to protect children and young people from harm and to hold perpetrators to account. So any instances of suspected child abuse or harm that has occurred or is occurring obviously needs to be reported promptly by all mandatory reporting requirements. The law, however, is in different jurisdictions, and again, you can see this in the handout, the different language used in different jurisdictions. In some places, it refers to as soon as practicable, and other places as soon as possible after forming the suspicion or the belief that a child is at risk of harm. So, what do those two things, mean? And what is the difference between those two concepts? And how soon do you have to act? There is no definitive answer in relation to this, and it is going to depend on the circumstances and the risk of harm. But both standards envisage reporting at the first available opportunity. This might be within hours. It could be the same day, or it could be within a few days, and this will depend on the information available. Some guidance, for example, we would trying to do some research to see what we could find that would be more definitive in relation to this. There aren't a lot of sources that you can refer to, so we're just going to refer to a few things as examples. But the Victorian Department of Education advises that within a school setting, a mandatory reporter's first real obligation is to ensure the immediate safety of the child. So if that requires medical assistance or some kind of other intervention, to address any immediate risks. And then as soon as that has been done, proceeding to report any incidents of suspected abuse. So immediate risks being a priority. There is some guidance legally about what is considered too long to make a report. In New South Wales, there was a legal case of a father who witnessed abuse of a child and took 5 weeks to get around to reporting it to police, and he was charged and convicted of failure to report under the criminal code. There was also a case of a psychologist who was struck off because they took many years to report a disclosure by a client. So yeah, we acknowledge that there are certainly times when there will be unavoidable delays. This will come up in our practice from time to time, where we're considering making a mandatory report, and we need to speak to the client to obtain more information or to confirm whether or not, where we've encouraged a voluntary report, we need to confirm whether or not they have reported to the police or taken that next step. So this can sometimes, depending on the risk, mean we may need to wait until the next day or several days until we can obtain that information to make a more meaningful report. And we're satisfied that this can still be considered as soon as reasonably possible. So it's a tricky balance between obtaining sufficient information to make a meaningful report and taking the necessary steps to form your belief about the risk of harm, and the need to report as soon as possible. But yeah, as I said, where the risk of harm is current or immediate, then action should be taken immediately, and police should certainly be notified in that situation. Over to you, Rachel, to discuss where and how reporting is done.
Okay, so as a general rule, if you're required under the Child Protection Framework, you report to Child Protection authorities. If it's under the criminal framework, then you report to the police. If you're required by both to report, then you would report to both. I would say that both Child Protection and police have information sharing. So if you reported to police already, then that will be coming to the notice of Child Protection authorities. Some jurisdictions make it really clear. So the ACT Crimes Act says that you don't need to report if you believe it's already been reported to Child Protection Authority. So you don't need to report under that criminal framework. And I guess that's a acknowledgement that there is that information sharing. Reporting, in terms of once you've decided where you're going to report, you have to work out how that's going to happen. It can generally be done online or by phone. Online, some states, the system will take you through a decision-making matrix with prompts. And I spoke earlier about the New South Wales mandatory reporting sort of tree that talked about the age of developmental age of children, but that is one where it'll take you through a series of questions to determine what the level of risk is there, keeping in mind that some of these online reporting tools can have their own inherent biases in them and have been criticised for that. So in terms of so that's where you'd be reporting, and now what you're going to be reporting, there's no baseline information required. And like I said before, it's not your job to gather evidence for this. It's simply your job to tell the authorities what your suspicion is and what it's based on. So if you believe that that abuse has happened or is likely to happen, you would make that report with the information available to you. Just some practical tips, I suppose. Put aside time to make that report. If you're on the phone, you might be on hold for some time to the police or child protection. And the other thing is that if you're doing it either way, it's okay to say you don't have certain information. You can also say that you don't want to give certain information. So remembering that if we're doing this in the context of our professional lives and we're talking about maybe betraying or breaching a client's confidentiality because we have to do it, we only have to give them as much information as is necessary. So if it's not relevant, then you don't have to give it to you. Give it to the authority that you're reporting to. So, for instance, any personal information that isn't helpful to this doesn't need to be provided. An example of this is if you look at the confidentiality table that we've provided, counsellors, their ethical guidance says that any disclosure of confidential information should be restricted to relevant information conveyed only to appropriate people for appropriate reasons, likely to alleviate exceptional circumstances. So that's an example of the fact that we're only giving as much information about our clients' circumstances and their personal information as we need to do. So in terms of the best numbers to call, there is an Australian Institute of Family Studies resource. I'm going to put it in the chat. I'm not quite sure if it's been provided in the materials, but I'm going to put it in there anyway, which sets out the resource sheet, which is information to people working in the child, family and community welfare sectors as to how you report. It defines it, and then it also gives you some numbers and websites that you can go to. So in terms of reporting, I think it's important to remember that child protection or police may not actually respond to a report. So just because you're making a report doesn't mean that there's going to be immediate action or that the child will be removed from their parents, or it will really depend on what information the police have. So you thinking that all child protection aren't going to do anything here, that's not a reason to hold off on a report. If you're required to report, you report, because it's also important to remember that it may be cumulative. So one report about a child may not go anywhere, but if there are multiple reports, particularly from different people in that child's lives, then that may actually lead to action being taken and that child being protected where they need to be protected. So you're important to remember here, you're not the decision maker in this scenario. It's just your role. It's not your role to decide whether something has happened or what response should be made in response to a report. You're just there to report a potential risk, and then you leave the rest up to the authorities. So we believe our clients, we respond, and then we give that to the authorities, who are much better placed to make their investigations and decide how to protect this child. We're really helping them to build a story, and they may not take action immediately. It may be after a few reports have been received. Okay, so on to legal protections for people who are mandatory reporters. In all jurisdictions, the identity of the reporter will be protected. It's a really important part of the mandatory reporting framework that people who report the potential risk to a child will have their identity and confidential information protected. So a deterrent, it can be a major deterrent for people thinking that they might be found out if they make a report. Anonymous reporting is an option in some jurisdictions, and that's something that should be considered. Now, I guess I acknowledge that anonymity will be more complex if you're in a small community, and you need to consider that. So if you're the only doctor in the community, it you know, you may be concerned that you are making a report and that you'll be identified just by nature of the report, even if they don't have your name. You should reach out to your organisation, and your organisation should be providing your report in making that, in supporting you to make a report in the organisation name if possible. Again, I acknowledge that it's not always going to be, you're always going to be able to be completely anonymous. The legislation also protects reporters from any action in a criminal, civil or administrative legal process. So, for instance, you can't be sued for defamation. Your identity will be protected if it goes to court. So, for an example, in family court proceedings, if the child safety file is subpoenaed, then the name of the reporter and any identifying features will be redacted from that information that's provided. Another example is that in criminal proceedings against an institution for child sexual abuse, reporters will be protected as well. So there's a case from 2018 where there was a criminal prosecution on the perpetrator for child abuse. The accused person actually sought to uncover the identity of the person who made the report, and they weren't successful in that. So the court was really clear that the identity of that person would be protected in that circumstance. Okay, the next one we're going to go on to is a cross-border scenario, because this is something that comes up for us at Knowmore quite often, and it also has been a recurring, I guess, request to the National Centre as well about more information. So what actually happens when we work across borders or children move across borders? We've got two scenarios here. You might have the child and the reporter in different places, or a child moving interstate. So to put it in context, at Knowmore we do a lot of phone work. So we might have a child that's in one state. We're talking to someone who's making a disclosure about that child in another state. The worker might be in another state again, and in some cases we might have two Knowmore workers who are themselves in different places. So it's quite a complex thing to navigate. If we're talking technically, legally technically, a state or territory law only applies in that place. Federal laws apply all over the country, but there's really very limited mandatory reporting requirements. In federal law, it's really just family and federal circuit court employees. So some laws, so the law will only apply in that place, but there are also some laws that specifically state that it applies outside of the state. For example, the Victorian Crimes Act says a person who's in Victoria or elsewhere who has information about a child in Victoria may be required to report. And in the ACT, there's also, I'm not going to go into the technicalities, but there's also a recognition that someone outside of the ACT may be required to report if they're not in the ACT. But what if it's not spelled out so clearly? So what we would say is that you should take a common sense approach. What is the purpose of these laws? And the purpose is there to protect the children in their state or territory, because they are on the ground. People who are able to protect them are on the ground. I think the safest course of action is to comply with the laws in the place where the child is and not where you are. So a child moving interstate, if you're perhaps somebody who knows that a child is at risk, but you know that they're about to be taken outside of the state, who do you report to there? There are protocols for information sharing between state child protection departments. It's likely that if a child's already on the radar of a child protection authority, then they'll be using those protocols. So if there's any doubt whether child protection on either place knows about it, then I would be making a report to the one that doesn't know about it, or to the state that the child's currently living in, to make sure that they know the child is actually moving. If we look at this cross-border scenario that we've got on the slide here, so if you're a social worker in a domestic and family violence service in Queensland, you're speaking to a client who lives in Queensland, and she tells you that her grandchildren who live in New South Wales are being sexually abused by their stepfather. You know, what would we do there? I would think that under the laws in both Queensland and New South Wales, you'd be required to report. But from a practical sense, look to the New South Wales laws where the children actually live and make that report. If you were to say, well, I'm in Queensland, I'm going to make the report in Queensland, there's a possibility that there'll be a delay in that information sharing, and New South Wales authorities being notified of any risk, and it could actually put that child at risk. So go to where the child is so that action can be taken for that child as soon as possible. We're making good time here. Okay, so that's that one. So just to wrap up and sort of get some key takeaways that we hope that you've got from today, we're firstly going to look at, when we're going through this broad decision-making framework, who is required to report, look at your profession, but also look at whether you come under that wider ranging criminal framework. What is the information that you've received? How did you come to your conclusion about the risk? And are there any exceptions that apply that mean that you're not required to report? And we really encourage you to use that spreadsheet, which has got columns as to the exceptions. When are you supposed to report? Well, that comes down to that timeliness issue. It may depend, but really it needs to be as soon as possible so as to protect the child if that's necessary. And when and how, which framework, look at which framework you're reporting under, and also to a reminder to think carefully about what confidential client information is relevant to that report and how much you need to actually disclose when making the report. And I guess as a wrap up, you know, a final decision on whether the law requires you to report doesn't mean that you're not going to report. So there's always that possibility that a voluntary report will be made. At Knowmore, we always discuss with our clients any mandatory reporting requirements, and we'll say that at the beginning of a call that, you know, everything you say to us is confidential, but there are exceptions to that. And if we're required by law to report, or if there's a risk of harm to yourself or others, we might have to report. So we say that up front and we're clear about that. But if the disclosures are made that maybe do give rise to a mandatory reporting obligation, we would talk to clients about the fact that that obligation may fall on them as well, and we'd encourage them to make their own report. We'd also support them to make that report. And I think that that's important to be able to offer that support, because it could be a frightening and a distressing thing for someone to do. Alternatively, we might ask the client for their consent for us to make that report, which means that we can preserve the relationship with our client and continue working with them. In accordance with the trauma-informed principles of empowerment and collaboration, that means that we can work with them and continue to work with them in a trauma-informed way, while still staying within those boundaries of confidentiality, which is also an important part of our trauma-informed approach. So remember to get advice. There may be advice lines and resources that you are available to you. Your professional body will be able to tell you if there are any secondary consult lines available. You might want to speak to your colleagues about this, but also be a little bit careful around that. If you speak to the colleague about a disclosure that's been made, you're sort of handing potentially an obligation over to them. And we also need to be careful that we're not telling our clients and sharing information that might give rise to vicarious trauma in the workforce. But just know that you're not on your own in this, and that there is support out there. So I'm going to hand over to Stacey. Thank you.
Thank you, Rachel and Amy. So we started our session today with talking about how our ethical obligations don't stop with our legal reporting obligations, and how keeping children safe, being a believing and trusting adult or trusted adult, acting when harm occurs, and supporting people to recover is all part of how we create a child safe and supportive environment. And we need to all do that together and know our responsibilities and obligations, because we all have that responsibility, and particularly across the lifespan. So really looking at how we keep children and young people safe, but also across to adults who experience harm as children. So from an organisational or practice context, we know that a child safe environment is one that creates a culture that empowers staff and people to protect children. Organisations that take action to promote child safety really enable early identification and ensure a timely response when harm has occurred. And it's how we create those conditions that reduce the likelihood of harm, increase the likelihood of identifying that harm early, and ensuring how we respond to concerns, disclosures, and allegations or suspicions of harm in a trauma-informed way, as Rachel's already talked about. So really want to encourage everyone today to consider the information that was discussed, how it can be applied to your practice, and how it can shape and strengthen your organisation's practice approach overall. And really want to end our session today by acknowledging the incredible wisdom on the screen, and thanking Amy and Rachel from Knowmore, and really hope that for everyone joining us today, that today's session has been really helpful. As a final note, there will be a feedback survey sent to you, so we would love your feedback, and please take the time to complete it. Thank you.
Thank you.
Thanks.